Bismillahirrahmanirrahim. Assalamu alaikum. Today's lecture is for junior lawyers and law students, and the topic is Specific Relief Act 1877. My name is Ghulam Sajjad Gopang. I am MBA Finance first position holder from IBA University of Sindh Jamshoro. I am LLB first position holder from Qazi Azam Law College Nawab Shah Sindh. I am the first advocate Supreme Court in the history of Nawab Shah Bar Association, and I am the youngest advocate in the history of Supreme Court of Pakistan. I am mainly practicing at Supreme Court Islamabad, having more than 1000 cases pending at Supreme Court and more than 100 cases reported in PLD law books of Pakistan. My three most famous cases are reported in 2019 SCMR page number 2063 about review jurisdiction, and my second famous case is PLD 2020 Supreme Court 293 pre-arrest bail, and my third and latest case is sacked employees case, which is reported in PLD 2022 Supreme Court page number 64. Due to busy schedule of cases, I cannot attend class. Therefore, I request you always to contact on my WhatsApp number 0333268266. You can drop a message. As soon as I, along with my legal team, will be free from our busy schedule, we will coordinate you and we will guide you. Please subscribe my YouTube channel Law Online with Ghulam Sajjad Gopang AAC GSG Law Firm at YouTube, and you can watch my Facebook account Ghulam Sajjad Gopang AAC and my Facebook page GSG Law Firm Nawab Shah Hyderabad, Karachi and Islamabad. You can follow them to have knowledge about the laws of Pakistan. Topic is Specific Relief Act 1877, which was promulgated on 7th February 1877. The relief, word relief means the remedy availing from the court, and the difference between specific relief and general relief is that general relief sought from civil court about damages or compensation, but relief under this Specific Relief Act is having 7 kinds. That is specific relief, like declaratory. 7 kinds of specific relief are: number 1, recovery of possession of immovable and movable property, and this relief is defined in at section 8 to section 11. Second relief is specific relief is performance of contracts, section 12 to section 20 define this relief. I have already delivered a separate lecture on specific performance of agreement. You can watch it on my YouTube channel. I have elaborated in detail in 40 minutes lecture. Third relief, specific relief, is rectification of instrument, which is defined in section 31 to 34 of Specific Relief Act. And fourth specific relief is rescission of contracts, defined in section 35 to 38, and fifth specific relief is cancellation of instrument, that is defined in section 39 to section 41. I will deliver specific lecture on this point, that suit for cancellation of any document, how the suit can be filed, and what evidence is required in it. Number 6 is specific relief is declaring the rights of parties otherwise than by an award of compensation. This relief is defined in section 42 and 43 of Specific Relief Act. Seventh specific relief is appointing a receiver, and it is defined in section 44. So, Specific Relief Act 1877 is divided into 3 parts. And those 3 parts are further divided into 10 chapters, and those 10 chapters are further divided into 57 sections. So Specific Relief Act is having total 57 sections. Most famous sections are section 5 and section 42, and number 1 section, the most important, is section 42 of the Specific Relief Act, and the entire laws and judgment of Pakistan from the civil court up to the Honorable Supreme Court are revolving through and through this section, section number 42, Specific Relief Act. and I will deliver a detailed lecture on this point as well. The point is, what is declaration under section 42? Generally, I will describe in a minute. Declaration under section 42 means that this declaration is an authoritative pronouncement by the court in respect of a person's right to property or his status. Declaration under Specific Relief Act is particular type of relief where there is no award of compensation but merely declaration of rights of parties. This is the definition. Section 5 is Specific Relief Act is also very important. It provides that how relief can be given. And the confusion which is found is that 20% lawyers of Pakistan file suit for declaration on the basis of sale agreement or lease agreement. This is incorrect. This is a wrong remedy that you avail. Honorable High Court and Supreme Court has elaborated this point in detail, that what type of suits fall within the parameters of section 42 of the Specific Relief Act. 2021 SCMR page number 1986, Honorable Supreme Court's latest judgment. Then 2014 SCMR page number 161. Then 2012 SCMR page number 930, and PLD 2006 Supreme Court 309 has elaborated this section 42, that under what circumstances, facts and grounds and pleadings you can file the suit for declaration under section 42 of the Specific Relief Act. Generally, we can say that declaration can be sought, suit for declaration and permanent injunction, perpetual injunction, or etc. can be filed on the basis of a registered sale deed or an undisputed title documents. However, on the basis of sale agreement or any agreement, any type of agreement, the only remedy available is suit for specific performance of agreement. That on this point I have already delivered a lecture in detail. You can watch it on my YouTube channel. Latest judgments on this point are 2022 SCMR page number 1009, gift mutation. Honorable Supreme Court has held that 6 years are defined in Article 120 of the Limitation Act, and that limitation is applicable to the suits instituted under section 42 of the Specific Relief Act. And then 2022 SCMR page number 912, these two latest judgments of Honorable Supreme Court. This judgment says that for correction in date of birth, matric certificate will be given priority and preference. And then the basic point that you have to understand, that who can file suit for declaration. You can file the suit for declaration in two categories. Either you are having a legal character or you are having any other right. So on these 2 points, the entire Specific Relief Act is revolving. Let's start. The Specific Relief Act 1877. Part number 1 is preliminary, and it is section number 1 is short title, 2 repeal, 3rd is interpretation. It clarifies obligation, trust and trustee. And then section number 4 is savings, and section 5 is specific relief, how given. This is very important. A specific relief is given by taking possession of certain property and delivering it to the claimant. Number 1. Number 2, by ordering a party to do the very act when he is under an obligation to do. Number one is suit for possession, and number B is an order or direction by the court, and number three is by preventing any party from doing it. An injunction is sought, preventing him, not restraining him to do anything. And D is by determining and declaring the rights of parties. That declaration is sought that he is the owner. Determining and declaring the rights of parties otherwise there by an award of compensation, and E is appointing a receiver. Preventive relief is defined in section 6. Section 7, relief not granted to enforce penal law. Then starts part number 2, chapter number 1, specific relief of recovering possession of property, starting from section 8, recovery of specific immovable property. Then is section number 9, suit by person dispossessed of immovable property. This is the suit that normally is filed when any person is dispossessed from his property. Suit for possession and permanent injunction. And then is section number 10, recovery of specific movable property. The section 11 is liability of person possession not as owner to deliver a person entitled to immediate possession. Under this section, the person in whose possession the property is right now is liable under this section 11. That liability of a person in possession not as owner to deliver the person the possession of that property. He is liable under the law that as he does not have any lawful authority to hold the possession, to maintain the possession of the property, then he is liable under section 11 to deliver the possession to the owner of this property. Chapter number 2 is specific performance of contracts. This is defined in section 12, and my detailed lecture is available. Cases in which specific performance is enforceable. And then is section number 17, bar in other cases of specific performance of part of contract. 18 is purchaser's right against vendor with imperfect title. This section deals the point of the title where it is imperfect, when it is not an undisputed title. Section number 19, power to award compensation in certain cases. And section 20 is liquidation of damages, not a bar to specific performance. And section 21 defines contracts not specifically enforceable. Which contracts are not specifically enforceable? A contract for non-performance of which compensation in money is an adequate relief. B, a contract which runs into such minute or numerous details or which is so dependent on the personal qualifications or violation of the parties or otherwise from this nature is such that the court cannot enforce in specific performance of its material items. C, a contract in the terms of which the court cannot find the reasonable certainty. D is a contract which is in its nature revocable. For instance, the contract was from 1981, and the expiry of that contract was till after the completion of 5 years. So this is 2022. The limitation is also crossed, and it is itself revocable, either through the date of expiry or through some terms and conditions which are described in the contract. So in the light of these two or any other reason, the contract itself is revocable. Then E is a contract made by a trustee either in the excess of their powers or in breach of their trust. A person who is not competent to execute that contract, that is already revocable. For an instance, if a contract is made, executed between a government or a semi-government organization and a private person, the person who has executed as a vendor or a vendee that contract is not competent to execute. An incompetent person, he is not the authority, he does not have the legal right given by that department, and he is executing it, so that itself has no value. Then F, a contract made by or on behalf of corporation of public company created for special purpose or the promoters of such property which is in excess of its powers. Same thing. G, a contract the performance of which involves the performance of a continuous duty extending over a longer period than 3 years from its date. This term is also fixed, that if it crosses 3 years, then again not enforceable. And final, H is a contract of which a material part of subject matter supposed by both the parties to exist as before it has been made cease to exist. So in these types, the contracts not specifically enforceable. So section number 22 is discretion as to decreeing the specific performance. And section 23 is who may obtain specific performance. It is defined in section 23. A is any party. B is the representative in the interest or principal. And C is where the contract is a settlement on marriage. D is where the contract has been entered into by a tenant. A and E is a reversioner in possession where the agreement is a covenant entered into with his predecessor. And F is a reversioner in a remainder where the agreement is such a covenant and the reversioner is entitled to the benefit thereof and will sustain material injury by the reason of its breach. If he is affected by that the violation of that agreement, he can file the suit. And G is when a public company has entered into a contract and subsequently becomes amalgamated with another public company, the new company which arises out of the amalgamation, then that company will be responsible. If you have executed a contract with ISCO or HESCO or KESE and another company takes over the charge of that electricity company, then the second one, the latest one, will be responsible for the implementation, execution and performance of specific contract. You can file suit against them. 24th section describes personal bars to the relief. Section 25, contracts to sell property. 26 is non-enforceable except with the variation. Section 27 defines relief against parties and person claiming under them. Section 27A, specific performance in case of a part performance of contract to the lease. And section 28, what parties cannot be compelled to perform. These are the parties defined in section 28 which cannot be compelled to perform. And section 29 is bar of suit for breach of dismissal. And section 30 is application of preceding sections to award. And chapter number 3 then starts of the rectification of instruments. Section 31, when instrument may be rectified. And section 32, presumption as to intent of parties. And 33, principles of rectification. Chapter number 4 of the rescission of the contracts starts from section 35 when rescission may be indulged, and section 36 rescission for mistake. Section 38 says court may require party residing to equity, and chapter number 5 of the cancellation of instruments, which is very important, that is section 39 when cancellation may be ordered. Just like in suit for cancellation of registered sale deed or special power of attorney on the basis of several reasons. Section 40 defines what instrument may be partially cancelled, and section 6, chapter number 6 is of declaratory decrees. Section 42, which is very important. Section 42, discretion of court as to declaration of status or right. Any person entitled to any legal character or to right to any property may institute a suit against any person denying or interested to deny his title to such character of right, and the court may in the discretion may make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. This is a very detailed section in which number of judgments are defined. Then is section 43, effect of declaration. Then what will be the effect of declaration? And section 44 starts on chapter number 7 of the appointment of receivers, and section 44 ends there, and chapter number 8 starts section 45 of the enforcement of public duties. Section 45 describes power to order public servants and others to do certain specific acts. Section 46, application how made. 47, preemptory order. 48, execution and appeal from the order when any decree is passed, judgment decree is passed, how the appeal and orders will proceed. Section 49, costs. 50, bar to issue mandamus. 51, power to frame rules. On the point of writ of mandamus in constitutional jurisdiction, I have already delivered a detailed lecture. This is bar to issue mandamus, the decree of mandamus. 51, power to frame rules, and part 3 starts of preventive relief. Chapter number 9 of injunctions generally, section 52, preventive relief how granted, and then chapter number 10 of perpetual injunction. Section 54, perpetual injunction when granted, and then is section 56, injunctions when refused. This is divided into A, B, C, D, E, F, G, H, I, J, and K. And then last is section 57, injunctions to perform negative agreement. Thank you.